There we go. All right. Welcome back, everybody. Recording has begun. How's everybody's week going so far? All right. I got to tell you, I'm not 100% sure at this point what we want to do with these larger work group sessions. I know one of the things, there wasn't a lot of response to the email about Harris Moderazzo and doing the PSRB. I'm just going to send out a doodle poll, include him and everybody, and see about scheduling something bigger or something with his schedule in mind. To pick up PSRB stuff. For the three groups that we've got going so far, I feel like most of what we covered was the same. Allison.
I'll watch the door, Kevin.
Thanks. Very similar topics for the other three groups. Although we did all come up with the same concerns around client competence and how to manage. There we go. How to manage cases with less competent clients. Okay. So, I think at this point, I guess for this, it's just, do we want to compare some things and make some notes between the two? Man, Jordan, what are your thoughts on this?
I think I was distracted trying to put out another fire on email.
No, fair enough.
Sorry. What was the question?
Oh, just since we have separate breakouts, I'm a little stuck as to how to best use our time here in the bigger group.
I think as we get closer, having people review work done in other breakouts to make sure that it's consistent across the different work groups will be helpful. Make sure our language is similar, that we're not having wildly different standards for the same, level of work. As for today, I don't have a great answer.
All right, then let's do this. Let's start with the big piece that came up in the PCR and habeas, and let's see if we can manage that a little bit in the civil commitment context, which is, let's talk client contact. And let's talk for a minute about what that looks like. I think for civil commitment side specifically, when we're talking about day 0 versus day 3 appointment, and whether that's something that we're looking at. I mean, we're looking at a much faster. So for those in the civil commitment side who didn't attend the PCR and habeas, are looking at lengthier initial contact timeframes. That just don't make any. They don't work in a civil commitment context. Like, we're talking 2 weeks. That doesn't work in a civil commitment context.
Considering the length of a civil commitment case as it stands right now is at maximum 10 judicial days long, like, no matter how you frame it, like, I think you have to have contact with your client within 24 hours of your appointment. Like, the people that are appointed on day 3, like, realistically, it's within like an hour of your appointment. Right. Like, if you're do all of the things that you need to do. And that we were talking about that a little bit, that when we're thinking about like what is the maximum caseload and what are the expectations, like to do civil commitment work effectively, you have to have flexibility built into your caseload so that you can just clear your calendar and go to the hospital if you're appointed on a case. And they're really unique in the scope of our practice, just because with everything else in the courts, like things can take a little longer, but like they just statutorily, they just cannot take any longer. So we must be on these very tight timelines.
Right.
And I know nothing about civil commitments, so this is just me asking a question. I mean, does it make sense that there needs to be a requirement that the person's office has to be within a certain radius of the state hospital?
I don't know that is strictly speaking necessary, depending on how we define contact. Ideally, you're going and
it doesn't have to be okay, I got you.
I mean, ideally, yeah, you're going in and you're having an in-person. I mean, I'm, from the practice that I did, but frankly, we had the local. It was in town, but or if it wasn't, it was in Coos County. So it might be a real quick drive over to visit.
It's not necessarily. Yeah, Allison, you go first.
Well, I think with our like recruiting challenge also, like especially for like, I know that Coos County is really, really hurting for commitment lawyers right now. Like, I mean, I think we set the expectations for like, you are going to see you need to make contact with your client. And like, honestly, for commitment clients, like phone contact does not really work. Like if your client is like totally deteriorated, like having a conversation on the phone is meaningless. So I think we do need to set the expectation that you're going to have an in-person contact with them within 24 hours of your appointment. And people just understand like that's the expectation. So if you're in Eugene and you want to take Coos County cases, then like you're going to drive a long way, and like that's fine. Like great if people want to do that, but we can't.
Okay, I was just trying to move the conversation forward because I know nothing about this area.
Yeah.
Well, go ahead, Bailey.
We're already in that position because appointment doesn't happen based on what hospital people are in. Appointment it happens based on their domicile. So I'm frequently having clients. I mean, I'm in Salem, so I'm only an hour from Portland, but that's still a significant time chunk that I have to take if I have to drive up to Portland. Bend, Albany, I've had clients, a lot of varying counties that I have to go see as soon as I practicably can. So that's typically how it is.
If you put the 24 hours in, practitioners will understand the 24-hour in-person visit. Practitioners will understand that they need to be able to make that sacrifice or that accommodation for that particular client.
Right. Yes.
Mm-hmm. And ideally, sometimes there's a elder care psychiatric hospital in Portland that takes referrals from all throughout the state. So like we'll have Lane County commitments who are admitted to that hospital in Portland. If we could get this really nailed down, it would be really great if we had like a pool of practitioners where even though it's a Lane County case, because somebody is in Portland, we could assign it to them so that my office is not spending the entire day going up to do that. But maybe that's a longer term conversation.
Yeah.
I mean, I mean, I don't know that it's necessarily a conversation for this forum, but that is actually that's an interesting point that I hadn't really considered before, which is, okay. It bears on, I mean, the standards would bear on that question of how do we support the attorneys doing the work in this practice area, given the distance.
I think
that could be a question for our next contracting session, Kevin, that we can bring up.
Because it feasibly bears on how many cases a lawyer can take. Like it depends. Like if you're being expected to drive far out of county, then you have less time to do the other things that you need to do.
Right.
And also working with different hospitals and their records release practices, that gets really complicated because our clients can't sign ROIs 99% of the time.
They're not supposed to have to sign ROIs either. I'm not yelling at you, Bailey. I'm reacting to the trauma of having had this conversation with hospitals all the time. Like, it's in the statute. You're supposed to give it to me today.
And that should not be the only cause for a continuance. It should be a dismissal if the records are not in my hands 24 hours in advance of the hearing.
Yeah.
I remember litigating that. Okay.
Can I ask a quick clarifying question for when this comes up outside of this group? You're saying that regardless of where the person is physically located, the civil commitment is filed where they live?
Yes. Well, they have right of first refusal. So it's supposed to be filed in the county they're domiciled in. If the county they're domiciled in refuses to take the case, then it can be filed in the county where the hospital is located.
Functionally speaking, like, somebody comes to the emergency room, like in the county where they live, so like in Salem or in Eugene or in Coos Bay. But then when a person is going to be assessed for inpatient admission, it just depends on like where is there an appropriate bed available. So there's like specific hospitals for people that have particular needs that are in different parts of the state, or there are counties that do not have an inpatient psychiatric unit in the county, and so they have to get beds somewhere else. But the
insurance as well
in their local county, so the investigator was in their local county, and they already decided that they were going to pursue the case by the time they get transferred.
Okay. Interesting.
Yeah. Okay. No, okay. So I guess my question, 24 hours, frankly, is a lot of time to my mind with regards to this. Although we do have to run up against you get appointed at like 4 o'clock. So is 24 the right standard? We might take more of a crack at that in our meeting on Friday instead of here. Sorry, go ahead, Allison.
I think depending on like the appointment day. So like if people are appointed on day 0 and Bailey, like, I would be interested to hear what you think about this. Like, I don't know that it is the worst thing to if you're appointed on day 0 to go sometime on day 1 to go and see your clients, because some of them will have been discharged just because they've got a good night's sleep and are ready to go. But also like for everybody who just got a hold placed on them, like, that means that they are not well. And so like, yes, we want to make sure that they understand that they have an attorney, and there's definitely work that we can do, like, even in that setting. But like, just in terms of like what is actually going to happen, like, you're going to say like, yes, this person is super not well, and then you're going to have to go back again the next day anyway. So I think if we're talking about day 0 appointment, I think meeting them on the subsequent judicial day, there's no problem with that. But
I would agree. I mean, we're usually appointed on day 1 anyways, because the document doesn't actually go through e-court processing until day 1. So, like, for example, I just met with some people. I just got I was appointed on day 1. I saw them on day 2. So that's typically my procedure anyway.
Okay. Yeah, I think so. And knowing that I'm going to have to rework this into more standard language, but something like in-person contact within 24 hours, if appointed on day 3 or later, a tighter standard?
I think if you're appointed on if you're appointed later than day 3, you have other problems. I know that.
Yeah.
Right. If you're appointed on day 3, like, you need to see them in person within the judicial day of your appointment, I guess is what I would say. Like, you need to have seen them on day 3.
Like, the day you learn of the appointment, you should see them by the end of that day.
Mm-hmm.
Unless you learn it as Kevin pointed out, unless you learn at 3:30 or 4 p.m.
I mean, even in that circumstance, like, and I have been at the hospital at 8 or 9 p.m. like many times. Like, so it's just the nature of this type of work. Unfortunately, we can't.
Yeah. Becca has her hand up.
I was going to say 24 hours too. I mean, at least in Washington County, we get day 3 appointments, but it's attorneys who have a whole nother caseload as well. So I might be in court until 5 and get back to the office and get an email. I'm, not necessarily going to see that person. And some of the hospitals won't let you in at certain hours or, certain times either. I just think there's a lot to work around. I think the day of appointment's a little tight, I think.
Yeah, the state hospital gets complicated because of how finicky some of the units can be with regard to contact. I have units that most of them actually will not schedule until at least the next calendar day on the day you call. And sometimes it's, we don't have time, the times you're available. Some units do allow you to visit at 8 or 9 p.m., but some of them don't. Some of them have large swaths of time where their visiting unit is also the family visiting unit. And so the state hospital has a lot of complexities there. And I've also had clients on 2-party petition at DOC. And so seeing them within 24 hours is literally impossible.
So I have a thought, and it might carry over across all work groups. What if we define an extenuating circumstance that we can plug that language into any timeline that we have, whether that's for post-conviction, civil commitment, habeas, that will allow for a clearly defined wiggle room. I don't want to make it so broad that OPDC would have trouble enforcing it, but we could include things like an extenuating circumstance is if you're appointed after 5 o'clock, like in a civil commitment. In a post-conviction, I can't think of what an extenuating circumstance would be. I don't know, maybe the institute, like an extenuating circumstance could be if the institution is unavailable.
So do we want to be that specific in our definitions? I mean, I think the overarching idea of these is that they are standards for practice. Now, there will always be reasons that the standards can't be adhered to, and acknowledging that in a preface is not a bad idea. Mm-hmm. I don't think we want to say we're dealing with lawyers and there's going to be reasons that lawyers come up with that they couldn't do this.
Yeah.
But we're dealing with lawyers and there are going to be reasons why these things can't be done. But I don't know that we want like an exhaustive list of
that makes sense.
Reasons.
Exhaustive, perhaps not, but I think there are some categories that might work for it. I mean, especially like my experience being in the dependency realm, the dependency timeline for child client contact specifically has an exception. You're not beholden to it if your client refuses to meet with you, right? Like that you're not gonna have ethical issues if your client is literally saying, no, I don't want you here at my school. I don't want you to come see me at my home. I don't need to talk to you. Okay. But we could certainly have those kind of categories. But Ginger, you said something that that the example that you gave, the institution's not available. There are, I know this was discussed in the civil commitment work group, and I think it's actually a good thing for us to discuss on a larger and possibly even towards the biggest end of this project, which is more bigger than just us, which is I think it's very prominent in the civil commitment context in that there's a lot of system inertia and stakeholders that just don't want or don't know how to follow the law. And that especially in the civil, I think Allison, you were the one earlier today who just said, here's the statute that says you have to give me this information. I've literally walked into the records office at the hospital in Roseburg. They have it posted on the wall right next to the records window. I point to the statute right there saying, this is right here is what tells me you have to give me what I'm asking for. Here's the order that appointed me, and here's my bar card that tells you that I'm their attorney. And the records department still says, nope, I'm not going to give it to you without an order for these records. So those kinds of institutional challenges, I imagine, are not exclusive to civil commitment. Is there something that we want to define, or a standard? The way we'd kind of talked about it in the civil commitment context is as a comment to some of the actions about an understanding of the need to engage. I think I used the term in educational advocacy for stakeholders about what their role is sometimes, and how that works. Meg and Ginger, I'd love your input as well on this being a bigger topic, possibly for a wider application.
So let me ask you this. When you say stakeholder, who are you referring to?
I don't know that there's a negative on that, right? Like, I don't know that there's anyone I would say isn't a stakeholder, unless like you don't think that they have any relationship to the work that you do, right? I'm talking about people who would generally be considered system partners. I mean, at least that's the term I've used in practice before, but folks who are a part of the system that we operate in, who may imperfectly understand their role and or responsibilities.
Okay, so I guess from my experience with like challenges that I have at the institution, that would primarily come from law libraries, because that's who does the scheduling of telephone calls and in-person visits. I would say 5 years ago was a much larger problem than it is today. I think that ODOC has really actively worked to come up with a centralized position. When I have an issue, I call the Dome building and let them know that a particular law library at a particular institution is causing delay, things like that. And I feel like ODOC has really addressed any issues sufficiently, when I bring those up. I have seen just a lot, on the pond recently about staff shortages in Multnomah County really impacting practitioners' ability to, visit their clients. And I think, if we're talking about the larger picture, I think what stakeholders, what the legislature doesn't understand is that every time you go to the jail and it's closed, it just adds time. So I don't know that maybe it's not that they're not appreciating it, and instead there's not a solution to the problem, but it appears that staff shortages at ODOC and anytime a correctional setting is really causing us to spend more time on cases, which eventually creates a backlog.
Right.
And I don't, like I said, with my practice specifically, I feel like PCR attorneys have it dialed in the sense that the law libraries are much more responsive to our needs than they used to be.
Okay. Allison.
I'm not sure if the question is, or the idea is to like build in an expectation that there will be like stakeholder education to the standards, or to, as Ginger was just saying, sort of understand that part of the time a lawyer is going to spend is doing that. But I have been, personally trying to do stakeholder education in my jurisdiction for 11 years. And I've been on the legislative work groups for 7 years, like with the hospital associations, talking to them about all of this. And like, they are not going to be educated by us. I think that is
right.
just the straight up bottom line. So I think definitely like understanding that is something that you just have to deal with, and we're like walking uphill. I mean, for us, and just speaking for us in commitments, like I think there's like a couple of places, like smaller counties, where there's like functioning relationships between the hospitals and the court and the defense bar, but in most places, and it's, I mean, the hospital, like, even though they should be like inpatient units, especially, like, I would imagine that when you sign on to be a medical director of an inpatient psych unit, you understand that there's going to be court involvement with some of your people, but they're just not a court system. So like the things that we would use with even like jails or DOC partners, where they're much more used to dealing with the courts and dealing with statutes. Like the hospitals, all the hospital systems have a huge legal department that I would imagine are telling them like, so what? Like, we've never been sued over that. So like from a liability perspective, like, tell them to go away. And like, there's never been a major consequence for that.
Okay. So focusing more on just knowing that this is going to be an uphill climb in some ways, as opposed to setting an expectation of, okay, gotcha. I took the comment as more of just like a, man, how do I put this? Like the general awareness that the system, the way that these systems interact with the legal system is, man, it seems so weird to try and put into words. It doesn't work the way we all think it should based on the law, if that makes sense, right?
I think if we're saying, and like to Ginger's point, like if we're talking to the legislature about like, here's what we need money to have time to do, like yeah, some of it is like going to court and talking to our clients and writing motions and all that, but like a good chunk of it is just like explaining to a person who's new at the institution that like, this is what happens and this is what I get to do. Or like, if you can't get in that day and you have to come back the next day, like there's so much just logistical admin that you have to deal with that is a drain on resources. I don't know how you account for that, but like, that's true. Like, that's a big part of what we do.
And waiting. So much waiting on hold, waiting to go through security at the state hospital, waiting for a lot of things, waiting for a client to wake up, so I don't wake my clients up, but sometimes I need to see them when they're asleep.
Meg and Ginger, is this a thing that you find to be common in your practices as well?
The waiting?
Sure.
So my overall comment is this, and then I'll address your question. I think, and maybe this is so basic, but I think that there is just a flat out misunderstanding of how hard our job is. It's like every step of the way is hard. And I just, from the legislature's perspective, I just don't think they're understanding that every step requires 10 baby steps. So to answer your question, well, what was your question? Because I do have an answer for it, but now I forgot.
It was about the waiting.
About the waiting. Okay, yeah. So in my practice, where a lot of the waiting comes from, so say we have a case where it's a child sex abuse case, and sure. Underlying counsel, maybe they did, maybe they didn't get all of the reports from CARES. Well, first of all, they shouldn't just turn over the CARES reports to us, because they are supposed to turn those back over, right? And so then we're caught in this, and not a dilemma, but we're caught in this cycle where, depending on which state agency did the child interview, we have to try and figure out, have we done a protective order from that particular agency before? We have to get a hold of county council. We have to go over the protective order for that particular agency. We have to get it signed off on by the Department of Justice. Everybody gets to weigh in on the corrections that they need. So it's like, even though we've been doing this, for 20 years, we still, and we're getting closer to having a standardized protective order, but it has to go through all these additional steps. So I think the waiting for us a lot of times is waiting for people to respond to something that we need versus waiting for our client to get to the visits. Because again, I think that the state correctional institutions are better about, it's just like you have to make an appointment. So it's a little bit different than a jail. So there's not a ton of waiting, at the jail or whatever, or at the correctional institution. I would say our in-court wait time is a lot different as well, because again, we have a specific time that we're going to go. Sometimes that'll get bumped. People normally get bumped that come after me because I am really bad at estimating time. So I go over a lot. Sometimes I go over by an hour. So that's completely my fault. But I've been trying to, so there's not a lot of waiting, physical waiting. It's more waiting for all these state agencies to respond. So, and just having to do the same thing over and over.
And I mean, that what you're speaking to there with the needing to make sure that your orders or working with new county council or whatever, that I think that fits into this, right? There are a lot of, I mean, we work with a lot of different courts too, and all of them do things vastly differently. And so there's, so I think we've nailed down that it is, we'll need to retool the language, but I think that that fits into the comment that we're going to want to add. We're going to want to add in. Cool. I think that takes care of that particular piece. Yeah, and then we talked a little bit about metrics, but it's not a big. Metrics are going to come later.
Yeah, but I do think that that's an important discussion in terms of, like what Allison was saying, in terms of wait time. Like that all should go into case wait. And I think that it's different. I mean, obviously it's different than in the criminal context, in the sense that, generally speaking, you're practicing in the county where your case is. So I just think drive time, all those, I don't know if the time it takes to get to your client is appropriately taken into account for cases like civil commitment, post-convictions, habeas, where you're having to travel long distances to see your client.
But you're likelier to have gotten that set up well in advance.
Yeah, definitely. But in terms of, whether or not I can take 12 or 15 ag murder cases a year, I don't know that the distance from my office to SRCI is put into that calculation. But I mean, this is a discussion that's way outside of.
Yeah, I think that's more the when we're dealing with model application. What I'm focused more on here is just like the aspect for the standards of making sure, okay, look, part of this work is just, you're going to beat your head against a wall repeatedly sometimes because stakeholders aren't always up on what their responsibilities are. Okay. That I think, I mean, mostly the areas that we covered, and maybe this is just a short meeting, mostly the areas that we covered across those were contact, communication, and knowledge of the underlying case the underlying law. So I don't know that there's a huge, and we talked a little bit about some of the specific, like the stuff that you just don't have time to do in civil commitments. So I think we're basically at a point where we're on the same page with the three groups. I don't know that we want to take a lot of time going into any of the individual work groups again, because we've got everybody here. I think it's just give everybody back 20 minutes and we'll continue with the breakouts. What are people thinking? Okay, I'm seeing a lot of head nodding, so I think that's where we're headed. So thanks, everybody. I appreciate us all meeting to get on the same page for some of these things. I am trying to get an actual, like, linguistically made draft put together, but there are a lot of things happening right now, and I do have extensive notes on what we've discussed. So this is going to be a work in progress. My hope is to get you like actual draft language. I just don't know how quickly that's going to happen. So thank you, everybody. I appreciate your time.
Thanks.
Have a great rest of your day.